All right, members, I detect a quorum, so we're going to open up Civil Justice Committee full. Madam Clerk, call the roll, please.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan,
Present.
Chairman Carter. Mr. Vice Chairman, you have a quorum.
Thank you so much. Any personal orders from any members? Seeing none, I'd like to, Representative Griffey, it's nice to have all of our lawyers back on the committee. All right. We've got a calendar today, so we're just going to start right off the bat. Item number 1, House Bill 581 by Chairman Reagan. Got a motion and a second. You're recognized, sir.
Thank you, Mr. Chair and committee. This bill is brought to us by the County Officials Association of Tennessee.
One moment. You have an amendment, I guess?
Yes, I guess we need to get that on there first,
Yep.
don't we? Drafting Code 5451.
That's what we have. Does the amendment make the bill?
It deletes Section 3 and puts a new Section 3 in, so it doesn't make the entire bill. But
Okay.
I'd like to have the amendment on it, discussing it anyway, if possible, sir.
Sure. Let's take the amendment up and put it on the bill. We're going to be voting on Amendment 5451. All those putting on the bill say aye. Those opposed, ayes have it. We're on the bill as amended. Chairman.
Thank you, sir. This bill, as amended, provides an additional avenue for notifying the next of kin in conservatorship proceedings. Current law allows only, and let me stress the word only, certified mail notice to next of kin. A problem exists for next of kin whose whereabouts are unknown, and that can be from extraordinary circumstances such as pandemics or other natural disasters, or the USPS can simply refuse to deliver because of difficulties with those kinds of things. This bill will alleviate a situation where no address can be found for the next of kin as well. It clarifies that medical records attached to a petition for conservatorship are confidential. This current law implies that the potentially disabled person has the burden to request their medical records be sealed by the court. This bill clarifies medical records may be retrieved and unsealed by an attorney representing the individual under conservatorship. It also clarifies that the petitioner is responsible for the cost of publication if applicable. With the amendment was on there, this is an explanation of the bill as amended. I stand ready to answer questions.
Any questions from any members? Representative Garrett.
Chairman Reagan, thank you for bringing this legislation. I've practiced and I've set up many conservatorship matters, and there's some definitely information that some of us would want to be public about our loved ones when they are sometimes in the final stages of their life and can't act upon themselves. Medical records is obviously very important. A doctor's opinion in that regard is also part of a public record. So I appreciate you bringing this and making that information. But for having to go to get a conservatorship appointed, this information would not be public. So I appreciate this bill. I appreciate the legislation. I'm proud to support it. Thank you very much.
Thank you, sir.
Chairman Ramsey.
And I also wish to thank the sponsor. My clerk and several other agencies have called me and endorsed the bill and supported it. So I appreciate you bringing it, sir.
Thank you, sir.
Members, any further questions? Oh, questions been called. Without objection, we're going to be voting on House Bill 581 to go to Government Ops, which is a very tough committee out here.
Yeah, I don't know who runs it.
It's those in favor say aye. Those opposed, ayes have it. Good luck at that committee, sir.
Thank you, Mr. Chair and committee.
All right. Item number 2 is House Bill 899 by Doggett. He's been requested to roll that to the final calendar without objection. Item number 3, House Bill 1126. It's been rolled 1 week. Item number 4 is House Bill 676. Representative Garrett, we have an amendment on that, 5816.
That's right, Mr. Chairman.
Got a motion and a second. Does the amendment make the bill?
Yes, it does.
All right, we're going to move that amendment onto the bill. All those in favor of Amendment 5816 say aye. Those opposed, ayes have it. We're now on the bill as amended. Representative Garrett.
Thank you, Mr. Chairman. Committee, this bill increases what is known as the homestead exemption. The homestead exemption has remained stagnant at $5,000 since 1978 for an individual, and for couples, it's been at $7,500 since that same time frame. What this bill does is it increases that exemption to $35,000, and it also increases it for a couple to $52,500. So with that, I'll be happy to take any questions. Otherwise, I'll renew my motion.
Members, any questions? Seeing none, we'll be voting on House Bill 676. All those in favor say aye. Those opposed, ayes have it. You're on to calendar and rules.
Thank you, Mr. Chairman. Committee.
So stay right there. Item number five is House Bill 1190, and it has no amendments, so. Got a motion and a second.
Thank you, Mr.
Garrett, you're recognized.
Thank you, Mr. Chairman and Committee. This legislation is brought by the Tennessee Bar Association, and all of us, or those that own real property, is deeded in your name, typically. One that is deeded in a trust, the trust sometimes is, the name of the trust is sometimes different than the name of the trustee. So it makes it difficult for indexing and when you do title searches to figure out the property of what you're looking for because the name may not match the actual trust. So what this does is it says that if you were going to put your property inside of trust, the deed has to be vested in the name of the trustee because that's actually who holds legal title to the trust is the trustee. So that's what this legislation does. I'll be happy to answer any questions. Otherwise, I'll renew my motion, Mr. Chairman.
Members, you heard the explanation. Vice Chairman Bricken.
Just a question. If the trustee changes, which certainly can happen in living trusts and such, what's the process for amending the titles there? I mean, it's just.
The better practice for a lawyer, if that trust is deeded in a name and that transfers, would be to quit claim that property in the name of the new trustee to make sure that the ownership is consistent with who the trustee is of the trust. In other words, it's recording another deed. That's called a quit claim deed.
I understand
Okay.
that part. Again, that's fine. I'll leave it alone. Thank you, Mr. Chairman.
Thank you.
Any further questions? I trust that explanation was.
Sufficient?
Okay, that's pretty bad. Okay, all those in favor of sending, oh, I'm sorry. Yeah, Robin Smith, go ahead.
Thank you, Mr. Chairman. I did have a question. I do know that it is the practice of some law enforcement officers to put their property in the name of a trust just to avoid public being doxxed, as it were. Is there any change in that public availability of that information just for the protection of our law enforcement? Thank you, Mr. Chairman.
No, there's no change in that policy, and I wouldn't say this, specifically addresses that situation, but if there is a police officer that wanted to put his property inside the trust can be named, and the trustee can be where you don't know who that he owns that property or she owns that property. And that's a common tool if you do not want your name attached to that public record. That's perfectly sufficient to do that.
Members, any further questions? Seeing none, voting on House Bill 1190 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it. On to calendar and rules.
Thank you, Mr. Chairman and Committee.
Members, Chairlady Littleton has the next three bills, and she is presenting oh, there she is. All right, all rise. Yeah. Okay, sure. So members, we're on item number 6, House Bill 237. Got a motion and a second. We have an untimely amendment by Representative Garrett, 6842. It is, Chair Lady, it's a friendly amendment, and it does two things. There's a technical issue that it does, and then it also strikes one line. What I'd like for it to do is Before we get to the amendment, I want you to explain the bill, and then we will address the amendment at that time. So, Shirley, you're recognized.
I think the amendment as it is did rewrite the bill, Mr. Chairman.
All right, got a motion and a second. We're going to put 6842 onto the bill. All those in favor say aye.
Aye.
Those opposed, ayes have it. As amended, would you like to explain the bill, or would you like Representative Garrett to explain his amendment?
He can explain his amendment,
Okay.
please. Thank you.
Sure.
Go ahead.
Thank you, Mr. Chairman Committee, for taking up the untimely amendment. The reason why we're doing it this way, and Chairman Littleton will have a time to discuss the bill as well, is there were actually two untimely amendments. We've rolled everything into one to be as efficient as possible. And so what the bill does in general is establishes when there is a custody order, and that custody order is decided by the judge. It clearly demonstrates that when that custody order is ruled, that he has to provide findings and facts and conclusions of law in his order. That comes out of, I believe, an East Tennessee case that they required the judges to make those fact determinations in their order. So if it is appealed, the Court of Appeals and Supreme Court can understand how the trial court arrived at his conclusion regarding a custody situation. So that is one portion of this bill, which is very good. Another portion of the bill, I'm going to defer to Chairman Littleton because it opens up another code that cleans up some information regarding the safe baby courts or safe haven courts that was left out, I believe, of some legislation last year. So I'll let her comment on that. Then the sentence that the amendment strikes was a duplicative sentence. It actually was already covered under the code that the bill referenced, so we simply just struck out that sentence. So with that, I'll be happy to take any questions on the amendment that rewrites the bill. Then I would defer to the Chairman Littleton on that section 36 that we're opening up to clean up a bill from last time. So with that, I'll be happy to answer any questions on the amendment.
Members, any questions on the amendment? Seeing none, Chair Lady, you want to explain the bill more further, or
Or you want me to explain the rest of the amendment, or?
well, the rest of the amendment makes the bill? So,
It does.
Yeah, so the
Okay.
rest of it, yes.
Okay. The other part is, last year, we had the safe haven where instead of 72 hours where a person could leave their child and not be charged if it was in a safe place, or we changed it to 2 weeks. But we omitted the section 36, so this just adds that bill to section 36.
Okay.
That-
Members, any questions? Representative Clemens?
Thank you, Mr. Chairman, and I'm not sure who authored which section, so I apologize. I trust that either will answer this as appropriate. I understand we're creating a presumption here for joint legal custody, which is great. But then it says, but the court shall have the widest discretion. What's the purpose for that widest language? I haven't seen that. Why not just discretion?
Representative?
Representative Clemens, thank you very much for that question. That's actually the current law. There's nothing that's being changed about the widest discretion, but if I may, the reason is because every time there's a case before this judge, those facts, those circumstances are unique to that case. So we want to make sure the judge has the widest discretion to make the best decision based upon the best interest of the child, and there's no uniform, way that that's going to be determined based upon the facts before. So that provision is unchanged in the code.
Okay, thank you. Appreciate it.
You're welcome.
Representative Parkinson?
Thank you, Mr. Chair, and either of the sponsors can answer this. So tell me about the joint custody part. I wasn't aware of it until my colleague brought it up. So.
This is to give,
Yep, go ahead.
This is to give the father more time, or the judge can consider the father more for joint custody. So, we've worked for years to try and say that the father should be involved in the child's life. So we feel like this is what this bill does.
Follow up?
And thank you, Mr. Chair, and thank you, Madam Chair. I want to thank you for bringing the bill. This is, part of what, I've been working on also, in cleaning up child support laws and, and DNA testing and things of that nature. And I just believe in my heart that, while the financial obligation is extremely important, but that time to me, is the most valuable thing that we can give that child, that time with those parents, especially if there are no aggravating circumstances that we should keep a parent away for. But thank you so much for bringing this bill. I'm looking forward to signing on to it. I appreciate you.
Charlie?
Yes, and of course, it is in the best interest of the child, always.
Members, any further questions? Seeing none, we're going to vote on House Bill 237 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it.
Thank you, Mr. Chairman
Stay
and
right
committee,
there.
for the indulgence with the late filed amendment.
Sure, sure.
And ditto to the Madam Chairman. Thank you.
Yes, sir. Item number 7, House Bill 465 by Chair Lady Littleton. There's a motion and a second. We do have an amendment on that as well, 6244. Is that correct? Is that the same tracking number? Okay. I have a motion and a second. Let's go ahead and put that amendment on the bill. All those in favor of 6244 going on the bill say aye. Ayes, and those no. Ayes have it. All right, 465 as amended, Chair Lady.
Thank you, Mr. Chairman. This says when testing a child for presence of controlled substance in the child's body, the department shall use a hair follicle test, but the department may also use other testing methods in addition to the hair follicle. The DAs have told us for years that the hair follicle is more usable in court, and so they had talked to me for a few years about this, so that's what it does.
Okay. Representative Parkinson.
Thank you, Madam Chair. And you know, I'm not in opposition to your bill. I just have a question and maybe a light concern in regards to civil liberties. So, you know, when they test, and maybe I'm wrong, and maybe legal can help us, somebody, but when we test by hair, does it tell us only if drugs are in the system, or does it tell us that there is a history of past drug use?
Charlie.
It tells of the history for 90 days. Some of them can stay in the follicle for 90 days. But it's basically to see if there are drugs in the system at that moment.
Okay, thank you, ma'am.
And Charlie, I also think that the hair follicles, it's more accurate. You can get false positives on different types of drugs, but with a urine test, it could open it up to a lot. But I think this one's a lot more accurate when it comes to the DNA testing. Chairman Curcio.
Thank you, Mr. Chairman. And I also just to follow up on that, because I think maybe I understood where you were going or what the nature of that was. Remember, we're talking about a child here, so there wouldn't be any history of sanctioned, so to speak, air quotes, you know, recreational drug use. We're talking about an abuse situation where a child shouldn't have, by any stretch of the imagination, had access to those drugs. Am I accurate? Okay. Thank you.
Chairman Farmer.
And thank you for bringing this bill. I'm in support of it. I just had a question. If there's a situation where a child has maybe just been born or something and there's no usable hair for the hair follicle test, does the department have the discretion to use another means as well? This doesn't lock them into having to do this for something that could slip by.
Charlie.
It does say they have that opportunity.
Okay, thank you.
Any further questions? Seeing none, we're going to vote on House Bill 465 to go to Finance Sub. Those in favor say aye. Those opposed, ayes have it. Off to Finance Sub, and rounding us out today for item number 8. House Bill 1231, I do have a motion and a second, and it does have an amendment as well, 5506.
5506, yes.
All right, got a motion and a second on 5506. We're going to put that on the bill. All those in favor of putting 5506 on the bill, say aye. Those opposed, ayes have it. Chair Lady Littleton, 1231 is amended.
Thank you, Mr. Chairman. This bill requires the on-site facility supervisor in charge at a secure juvenile detention or correctional facility to immediately report any security breach or any escape by a juvenile who is alleged or adjudicated to be delinquent for the act. And if they fail to do that, if they intentionally fail to report, then it becomes a C felony. Because, you know, a couple of years ago in Nashville, we had the escapees from the juvenile detention, and they went out themselves to find them. So this just tells them if they intentionally do that, they're going to be punished.
Well, that facility was in my district, and I've favor of this bill. It was an issue, and it continues to be an issue with that one particular facility. Members, Representative Clemens?
Yeah, thank you, Mr. Chairman. I'm in favor of the bill, too. I just had a question about the, it says they shall immediately report this, but then it provides this list of very detailed information that must be in that report. So is there some leeway there with how soon after the breach or whatever occurs for them to actually gather all this information?
Chair Lady?
The intent is when they learn of the escape that they need to report it immediately to law enforcement.
Okay, and I appreciate that, and I support it. I just, there's a list of things here that have to be in that they might not have at that very exact moment that they realize it. So I just want to raise that issue and give it some consideration. Thanks.
Nope. Any further questions? I'd like to maybe next year to notify the representatives as well, because I found out on the news. I mean, I'd like to find out as well, but law enforcement's a good start. Okay, no further questions. We're voting on House Bill 1231 as amended to go to calendar and rules. All those in favor say aye. Aye. Those opposed, ayes have it. Thank you.
Thank you, Mr. Chairman and committee.
That's it. Members, any further announcements? Seeing none, entertain a motion to adjourn. All right, we're out.